the judgment, Robinson and his minor Sheikh Khalid bin Sagar al-Ghazali.
For the reasons which are given in writing, and after considering the parties' representations, we make the following orders. 1, the appeal is dismissed. 2, the cross-appeal is dismissed. 3, the appellant's application for permission to appeal to the Supreme Court is refused. And 4, there is no order as to costs.
Appeal in the matter of X Limited and others, and the commissions for the Her Majesty's Revenue Customs.
Yes, just before you start, Mr. Firth, it's been listed as X Limited, but there's an order removing anonymity, isn't it? Yeah, you should, yes.
That's correct.
Yes, so nobody told the usher, but it's officially Candor Limited and will be so reported.
Yes.
I don't need to make an order because the order's already been made.
Exactly, my lord.
But I say it's already been made. I can't find it.
I think it's more the absence of an order.
Yes, you're quite right. It's the absence of an order. Yep. Very well. Thank you.
Thank you. Before I begin, can I just ask whether the court's had an opportunity to read the skeleton arguments and the tribunal decision in this case?
We have. We've read those, and indeed, not perhaps in all the detail you want to take us to them, but we've read the authorities, so we're fairly fully on top of it. And so far as we're concerned, you can come more or less straight to the point.
I'm grateful, my lord. So there are two issues. First is whether, as a matter of law, it's correct that the first-tier tax tribunal has no power to permit participation in a third-party information notice approval hearing. I'll refer to that for shorthand as an approval hearing. And the second is whether the Upper Tribunal applied the correct test and reached a permissible conclusion in deciding that the first-tier tax tribunal will nearly always hold the approval hearing in private and should do so in the present case. So those are the two issues.
I have to say, Mr. Firth, one of those issues do not include the 3 pages in your skeleton argument complaining in rather colourful language, if I may say so, about the behaviour of one of the revenue case managers. I'm bound to say we didn't find that helpful or appropriate.
Understood, my lord.
Sorry, I didn't mean to put you off your stroke, but I thought I'd say it now rather than put you off a stroke later.
In terms of the structure of my submissions, I want to deal firstly with HMRC's preliminary point. Then I'm going to take you through the legislative scheme as quickly as I can, knowing that you've already had a chance to consider it. I'm going to elaborate thirdly on 2 fundamental principles, the access to justice principle and the open justice principle by reference to the 2 Supreme Court cases, Unison and Horrelampus. And then I'm going to deal, in light of those, that context with the specific 2 questions that this court is being asked to decide. The preliminary point I can deal with quite shortly, I hope, which is HMRC say, well, even if I'm right on the first point, I don't have the findings of fact necessary for this court to say, yes, permission to participate should have been granted. And the reason for that, and my learned friends right, is because this case has pursued an unusual procedural history. We made our application, we asked for a hearing, and the FTT notes that at paragraph 10 of its decision. But rather than hold a hearing, the FTT went straight to a decision on the paper, saying we don't have power to even grant what you're asking for. There was never an opportunity.
You say unusual. If they're right, it was exactly the right thing to say. Well, so, but anyway, the fact is there haven't been any factual findings. What do you say about that?
What I say is that if I'm right that the first-tier tribunal was wrong to decide it had no power, then you should remit it. And
yes, well, that must be right. I think, Ms. Anderson, that you'd accept that's
Thank
right.
You. Well, I thought I could take it shortly, and I've taken it shortly.
Thank you. Yeah.
With that in mind, then, can I take you please through the legislative context? If I can begin with Schedule 36, it's in your authorities bundle behind, hopefully, tab 1.
Yep.
Paragraph 2 of Schedule 36, and this is the Finance Act 2008, is the power for HMRC by notice in writing to require a person to provide information or to produce a document. It's paragraph 3 that we're concerned with. An officer of HMRC may not give third-party notice without the agreement of the taxpayer or the approval of the tribunal. We're concerned obviously with the approval of the tribunal. Subparagraph 2 provides for the opportunity to ask the tribunal, and 2A is a provision I will place some emphasis on, which says an application for approval under this paragraph may be made without notice except as required under subparagraph 3. Subparagraph 3 sets out some preconditions before a tribunal may approve a taxpayer or third-party notice. And obviously the court will have had opportunity to look at that. I would place emphasis on point E. In the case of a third-party notice, the taxpayer has been given a summary of the reasons why an officer of HMRC requires the information of documents. And that will become relevant in my submission when we look at Morgan Grenfell shortly. So that is the power or the basis on which HMRC may first decide to seek information and then seek approval from the tribunal.
And there are very important safeguards within subparagraph 3, aren't there, for the taxpayer and the third party in respect of whom the notice is sought?
Yes, my lady. And the effect of approval that you can see in subparagraph 5, where the tribunal approves the giving of a third party notice under this paragraph, it may also, sorry, I'm mistaken. A missing reference there, but the point is a simple one, which is that the right to appeal does not apply where it's been approved by the tribunal.
Yes.
I'll find that reference.
Paragraphs 29 and 30 are the appeal
I'm
rights.
grateful, my lady. The tribunal is defined later in the schedule as the first tier tax tribunal unless otherwise provided. And in my submission, I'm not sure this is disputed. That takes us to the first tier tax tribunal procedural rules. Now, I say that's not disputed because I think my learned friend accepts that, for example, on the open justice question, the private or open hearing, Rule 32 of the FTT rules is the correct rule to apply. So I believe it's common ground that we must go to the first tier tribunal rules. And if I can ask the court to do that behind tab 2 of the authorities bundle. Rule 1, paragraph 2, these rules apply to proceedings before the tax chamber of the first tier tribunal. Rule 1, subparagraph 3, definition of appellant includes a person making an originating application, which is what an application for approval would be. And you can see hearing over the page 61. Hearing means an oral hearing and includes a hearing conducted in whole or in part by video link, telephone, or other means. The definition of party means the appellant or the respondent. And respondent, just underneath that, in point A, Roman 2, in proceedings brought by HMRC alone, a person against whom the proceedings are brought or to whom the proceedings relate. Rule 2, paragraph 2 is the overriding objective, which is similar to the CPR overriding objective. Rule 5, paragraph 1, subject to the provisions of the 2007 Act and any other enactment, the tribunal may regulate its own procedure. Subparagraph 5, in particular, without restricting the general powers in paragraph 1 or 2, the tribunal may, by direction, and could I just ask you to read D, F, and G?
Yes.
Rule Rule 19, I'm sure the tribunal will have looked at in its preparation, given that both parties refer to it in their skeleton arguments. That's on page 72. Rule 21 provides for the commencement of proceedings by way of originating application, which is what I submit is what happens where HMRC seek approval of a third party
Sorry,
installation.
which rule?
Rule 21, my lord.
Thank you.
Rule 23 states that when the tribunal receives a notice of appeal, application notice or notice reference, the tribunal must give a direction allocating it to one of the capitals of the case. Rule 29 deals with determination with or without a hearing. The effect of which is essentially a matter cannot be decided without a hearing unless each party has consented and the tribunal considers that it's able to decide the matter without a hearing.
That's a decision to dispose of proceedings.
Yes, but in the case of a third party application notice for approval, disposing of the proceedings would be the decision whether or not to approve the third party notice.
I see why you say that. It might be right. All depends what you mean by proceedings, which presume not a defined term.
Certainly speaking for my part, Mr. Firth, at some point I would be assisted by your submissions about exactly who is or is not a party for the purpose of an approval application. It may not matter at the end of the day, but it may matter whether one keeps firmly in mind that sometimes there's the third party itself, and sometimes we're talking about the taxpayer. I may have misunderstood, but so far at least, it's my fault, I'm being rather slow, but I would certainly benefit if you could help us, please, on what the legislation says about taxpayers as distinct from the subject of the third party notice.
My lord, I'm not sure these rules say anything specific about that. What it does say is the definition of respondent, which is the person to whom the proceedings relate. And in my submission, it would relate to both the taxpayer, whose tax affairs are being investigated, and the third party, who's going to be the subject matter and have the obligation to comply with the third party.
Well, I don't know. I mean, the more one looks at these, the more one thinks that actually the draftsman didn't have this particular procedure in mind at all. Now, you may say, well, it doesn't matter, it's got to be fitted in somehow. But the language is not very appropriate for an approval application. If you look at the definition of a party at page 61 in the bundle, it means a person who is an appellant or respondent in proceedings before the tribunal. The revenue, when it's asking for a application notice, it'd be very odd to describe it as an appellant. So asking for a third-party notice.
Well, they would be an appellant because of the definition of appellant, specifically subparagraph 3A, the person who starts proceedings, whether by bringing or notifying appeal.
You're quite right. Thank you. No, that's a fair point. Making an originating application, and that's what you said earlier. This would be an originating well, it would either be an originating application or it would be an or otherwise.
It would be one of the two, I would say.
Yes, no, fair enough.
But in an approval notice application, the respondent would be, if it's a third-party notice, the third party, not the taxpayer.
Except you say at page 61 the definition of respondent is extended beyond that.
It's the person to whom the proceedings relate.
Yeah, but query, what does that phrase actually mean? Your submission is that means the taxpayer.
It means both the taxpayer and the third party. The taxpayer...
Well, that they would be covered by a person against whom the proceedings are brought.
These third-party approval, it's an originating application. It's not specifically brought against the taxpayer.
Oh, I see. So you say that we should construe the phrase "to whom the proceedings relate" to include not only the person who is actually the subject of the third-party notice, but also the taxpayer.
My submission is that on a proper reading of that paragraph, that it does relate to both sets of persons. I mean, in this appeal, that's rather academic because I have both the taxpayers and the third parties as my appellants. That's why we've got 20.
I understand that, but it may matter. It may not matter at the end of the day, but it may matter because whatever we say in our judgments, we've got to try and get the law right. And if the law, in fact, distinguishes between the position of a taxpayer and the position of a third party, then we may have to say so.
I couldn't disagree with that, my lord. My submission is simply that the proceedings relate is not a tightly confined term. It's rather.
You see, I'm wondering whether actually this is apt to be described as proceedings at all. Can I put a different sort of approach to this whole exercise? What's really going on here is an investigation. An investigation which may never actually lead to anything happening in a tribunal at all, by way of a tax dispute. I mean, in theory at least, you could envisage a legal system in which the tribunal never gets involved. It's a bit like the police when they're investigating a potential offence. They just do their investigation. Now, as it happens, from time to time in our legal system, we have chosen occasionally to insert into the investigation process a judicial officer. So sometimes it's Justice of the Peace who may have to grant a search warrant to the police, or sometimes in this context, it's, as it happens, it's the FTT. But I'm not myself sure that what they're doing really is judicial proceedings at all. I think what they're doing is they're just adding a sort of safeguard so the public can be confident that the executive is not just going around extracting information for no good reason. And you could say, in theory, a very senior officer has to approve the notice. But here we've chosen to say, well, it has to be done with the approval of the tribunal. But does that convert it into judicial proceedings?
My submission to that would be twofold. First of all, paragraph 3 specifically refers to an application to the tribunal. And I think maybe without notice. That feeds in my submission into the FTT rules, which talk about originating applications. So in my submission, they clearly are proceedings before the FTT. In terms of the second question, well, are they judicial proceedings? In my submission, they are, because the FTT can only act in a judicial manner. It's not set up to do anything else. And I think this point is dealt with in the Wiseman case, which the court helpfully referred us to. So I'm going to take you to that shortly, in terms of whether the principles of, in that case, natural justice do apply to approval-type proceedings. So those would be my two answers to your questions, my lord.
Thank you.
We don't actually have, do we? Or if we do, I haven't found it. The form of the application for third-party notice made by the revenue.
We don't.
There must be a standard.
I couldn't tell you, my lord. I don't see them.
It's not disclosed
Not disclosed.
in general.
No.
I'm not sure it is a standard form. It may have changed since my day, but in any event, it wouldn't be disclosed to either the taxpayer or the third party. Can I just ask you this? In this case, the taxpayer and the third party's interests are aligned. You're acting for all of them, and there's no conflict. But there are lots of cases where third parties are, for example, banks. There's the Ulster Bank case, for example, and the Bank International Luxembourg, where the banks have nothing to do with the taxpayer, save that the taxpayer has accounts with the particular banks. And the banks are then subject to a third-party notice, which, save where it's very onerous for them, and they may object on grounds of onerousness, they won't have any real problem with complying with the notice at all. In that situation, do you say that both are respondents to the revenues application in a third-party notice situation?
Yes, my lady, because the proceedings relate to both of them. They relate to the bank because obviously the bank is the one who has the obligation.
Well, that's without question.
Yes.
But I'm interested in how you say the taxpayers brought in a case like that, which is very different to this case.
Because the proceedings relate both to the taxpayer's own tax affairs and to information about that taxpayer. So it's,
But what's the consequence of that? You say that the taxpayer has a full right to participate in that application process, do you?
no, my lady, the crucial nub of my submission is that the FTT has a power, and it's a power that may well be exercised in only limited cases. You might even say unusual cases, where the taxpayer or the applicant, the exercise of that power, can persuade the tribunal that that is an appropriate step to take. So I've tried to be clear, and I want to be very clear. I'm not saying that there is a right. I'm not saying it should be the case in every case. And I accept it might even be quite extreme and quite limited circumstances where the power is exercised. But the burden of my argument is that there is a power, and the FTT should consider whether to exercise that power if asked to do so.
And what are the principles that would guide the exercise of that discretion?
Well, I'm going to take you to two cases, the Asif case and the Wiseman case. The Wiseman case is the House of Lords say there was nothing unfair about the procedure in that particular case, but a majority of the House of Lords say, but we must not rule out that the tribunal has the power to invite further participation from the taxpayer in an appropriate case. And an example is where there's something that appears to be mistaken in what is referred to in that case as the counter statement from the revenue, which the taxpayer hasn't seen. And so the point of that decision in my submission is that, well, yes, there may well be good reasons for generally not allowing participation, but there is a power to allow it. And my lady, you're right, then we have to consider what circumstances might that power be exercised. Well, Wiseman gives us some guidance. I'm going to take you to that shortly, my lady.
And presumably there'd be a right of appeal arising out of a refusal in that situation. Would you say?
Well, it might have to be judicial review, I think you would say.
Well, look, I couldn't say that because the present case is an appeal from a refusal to allow participation. So no, it would be there would be a right to appeal a refusal to exercise the FTT's power. But if it's
Where is that? Forgive me for interrupting you. But don't answer this immediately, but certainly at some point, I'd quite like to see what is the source of this appeal.
Well, again, I probably, well, no, I can't show you because it's not in the bundle, but it would be an error of law in a decision of the FTT in relation to a case management decision.
I see. I don't take time on it now, but at some point I would be assisted by just being reminded of the precise statutory provision under which the appeal to the UT took place. Because it's not impossible, in theory, to have judicial review of the FTT. In the immigration context, I've certainly sat to consider an application for judicial review of the FTT.
I'm picking up my Lord's point. If this had been a challenge to the approval, that could only have been pursued on judicial review.
I accept that, my lady. Yes, and there are examples, my lady,
Yes.
you've sat in the Cotton case where that's happened.
Yes.
So I accept that.
Can I just pick you up on something you said in response to one of the earlier questions? You said there is a jurisdiction effectively to allow representations or a hearing at which the taxpayer can attend, and that you said that the tribunal must consider whether to exercise that discretion if asked to do so. What form would the asking to do so take?
It would be an application of the nature that was submitted in this case, which is, I mean, there is no formal procedure as you have in the CPR context for applying to the tribunal. You send in your document setting out what you want and the reasons why you want it, and then that's an application. So that would be the form. But equally, the tribunal could, of its own volition, decide actually there's something about this case that we.
Well, all right, but I take that point, but this is only going to be useful to you, and in truth, will normally be of interest to taxpayers if it's a jurisdiction they can invoke in some way, and then challenge when it isn't, when the tribunal decides not to do it. So you simply say, is this right, that what the taxpayer does is say, we have heard, query how, that you have been asked to approve a third-party notice. We wish to be heard.
But we would get a summary of the case HMRC intend to make under paragraph 3.
Not the case they intend to make, the reasons why the officer reasonably requires the information or documents.
Exactly. So we would know that HMRC are intending to apply one, and that at that point, if you think there is a good reason why you should be permitted, then you'd have to send your application, as we did in our case.
That those provisions can be dispensed with in a case where it would seriously prejudice the assessment or collection of tax.
Yes, madam. And in that case, you wouldn't know.
You couldn't invoke it in those circumstances.
But let's just take the ordinary situation where subparagraph E does apply. So as the taxpayer, you've been given a summary of the reasons why an officer requires the information and documents. What other rights do you say the taxpayer has? You're not expressly given the right to make any representations, for example. Whereas we know from paragraph D that the tribunal must be given a summary of any representations made by the third party. So this is why I'm suggesting to you that one does have to be quite careful in analysing this statutory scheme, always to focus on what exactly is being talked about, when it's the taxpayer, when it's the third party, when perhaps it's both. You seem to be suggesting that the taxpayer can come knocking on the door of the tribunal just because they've been provided a summary under paragraph E.
But it's not E that gives them the ability to ask the tribunal to exercise its power. That is the practical circumstance in which the taxpayer might want to ask the tribunal.
Yeah. And presumably you would also say that somewhere, not expressly, but somewhere by implication, there must be a right for the taxpayer to make representations.
No, my lord, I've tried to be clear about this I was very clear about it to the Upper Tribunal. I've tried to be clear about it in my skeleton argument. I want to be clear before this court. We're not saying there's a right.
No, it's sorry, I'm not explaining myself sufficiently clearly. Are you saying that the taxpayer has a right to make representations to the revenue? I'm not talking about the tribunal for the moment.
There's nothing that can stop a taxpayer doing that, and we know in practice, and this is recognised by the Court of Appeal in Derren, that if the taxpayer does make representations to HMRC, HMRC will put those before the tribunal. So as a matter of practice, that's what happens.
Yeah.
I mean, I don't really think you need a right to make representation to HMRC, because it's just something you can do. It's a freedom more than anything.
Yeah, but all right, can I just ask you a little bit more about this? So in the subparagraph E situation, where all that's happened is that you've been given a summary of the reasons, and you wish to appear at the hearing, so I think you're saying that you have become a party, even though actually it's your application notice to have a hearing which brings you to the attention of the tribunal for the first time. You've never been made a party until that point, have you?
You were a party because the proceedings relate to you.
I see. So, but at that stage, will they have had to serve you of their application to the tribunal?
Well, paragraph 3(2)(a) says an approval under this paragraph may be made without notice. So in the first place, there's nothing to stop HMRC making it without notice, but then the tribunal must decide whether to determine it without notice.
But the notice is to the third party if it's a third party notice, not to the taxpayer. The taxpayer is only entitled to the summary of reasons why the officer reasonably requires the documents.
Well, there's no right to notice. It's simply saying it may be made without notice.
But the notice is not to the taxpayer, or do you say it is? The notice is to the third party.
That's not specified, my lady.
Well, so you say that when the revenue is seeking approval for the giving of a third party notice, the notice must go to both the taxpayer and the third party. Is that what you say?
If there is to be notice, so then yes, I would say that's right, because both will be respondents under the tribunal's own rules. And if that's not right, then, well, in my submission that is right, because that's what the FTT rules say.
But can the FTT rules create a power which is not created by the primary legislation?
Yes. I mean, the FTT rules are there to govern FTT's procedure. So this is a matter of procedure for the FTT.
Right.
How do we determine this particular application from HMRC? And Rule 32 about open hearings is part of that body of rules that applies. And equally Rule 5, which gives the FTT general power to manage its own procedure, is part of that body. So if the legislation prohibited it, then I wouldn't have an argument, because then that would the FTT rules say subject to any other enactment. But they don't prohibit it. In fact, they specifically envisage it may be made with or without notice. So may is used instead of shall. And when we look at Supreme Court in Haralambus, that's concerned with provisions that say shall be made without notice.
But that's 2 capital A, is it? That's your submission based on 2 capital A.
Yes.
Well, can I suggest to you a possibly different interpretation of that? That all it means is that they need not give notice, and so they're not doing anything unlawful if they make the application for approval without giving notice. That's all it means. It doesn't say anything about what the tribunal's powers are.
Well, I'm going to take you to the Asif case, which does deal with that issue where an application may be made without notice, and it says, well, actually, notice should be given unless there's good reason to the contrary. And then I'm going to take you to the Wiseman case in the House of Lords, which concerned an approval of an intention to invoke an anti-avoidance set of provisions, where there was quite a closely prescribed set of stages to that procedure. But nevertheless, a majority of the House of Lords said that the tribunal must retain the right to invite further representations if it considers appropriate, and that same logic must apply in this context.
But that wasn't. I know you're going to take us to Wiseman, so don't let me take you out of order, please. But that was a case about the taxpayer, wasn't it? It's whether there was a prima facie case against the taxpayer.
Correct.
That's not to do with third-party notices. Is that right?
Obviously not, my lord. It's to do with the transaction securities anti-avoidance rules. But the logic of the House of Lords in saying that here's this statutory framework for the judicial approval of HMRC, the revenue's right to invoke a set of anti-avoidance rules. In the ordinary case, the statutory procedure is enough, to be fair. But we must not rule out, we must not take away the tribunal's power that in some cases it may be appropriate to invite further representations.
Yes.
And that logic is equally applicable here.
Just a couple of loose ends before we let you get back to your structure. Like my lord, I would just like to be reminded at some point, either by you or Miss Anderson may get in first, but of the primary legislation substructure which lies behind the right of appeal, and also the making of the rules, because at the moment it's at the back of my mind that the procedure being followed here, which arises out of a distinct set of statutory provisions, simply isn't caught by the FTT rules at all. You may be right that it is, but I would just like to have that pinned down. Because these don't look to me like proceedings, a phrase one comes across from time to time, or a word one comes across from time to time, and can have different meanings in different contexts. But and in connection with that, I would like, and this will be a matter from Ms. Anderson, just to see in what form applications for third-party notices are made. If you're right that they have to be made under Rule 21, they have to be made in the form of an originating application or what's described as a reference to the tribunal. Neither of those appear to be defined terms, or if they are, I haven't spotted the definition. How it's done in practice might cast some light on that, although I agree it can't govern. I dare say all this will run into the sand, but I think, speaking for myself, I'd like to have it pinned down, mixing my metaphors.
Yes, my lord. I will do my best. Unlikely I'll be able to produce anything over lunch due to chambers not being open and the usual ability to...
Well, let's see how we go. I didn't know chambers. Oh, right, there we are. No, of course, whatever difficulties you have, we'll have to work around them. That's fine. But thank you.
I'm grateful.
My lord, may I just clarify? What you would like is the original means by which, putting it neutrally, HMRC engaged the tribunal in the proceeding, and then afterwards the appeal structure, so the tribunals, courts... And
well, the first one, I mean, I think what I was asking for, my lord and my lady may think I should have been asking for something else, is the procedure under which an application for approval under
yes,
2A is made.
plus what follows after that, the
form in which it's made.
Sorry? Yeah.
whether there's any...
You don't have to wear your mask while you're addressing us, thing. That's
Sorry,
not a problem.
sorry, my lord, I shouldn't really be addressing you. I just simply
No.
wanted to clarify exactly what it was you wanted, whether it was just the originating application. If we
That was all I wanted on that particular point. More generally, I just wanted to understand the powers and the primary legislation under which the rules are made,
right, so it's
and any right of appeal against the refusal of the application, which is what Mr. Firth says was made here. And this has come to us as an appeal against the decision on the refusal of an application, isn't it, ultimately? And I'd just like to understand that procedure.
My lord, I just want to clarify, there are obviously two things going on. One is the HMRC Schedule 36 approval application, if we call it that. And then this is concerning the appellant's own application for directions.
Yes.
Which has been appealed when it's been refused.
Exactly.
So there's sort of two.
No,
get to the bottom of which bit it is that you really want to see. Obviously, the originating application, I think it's agreed there's no appeal from that. It has to be judicial review. So it would just be the appeal structure from the directions application. If we
Yes.
do that.
Yes.
So and that I think we can easily provide.
I hope I haven't complicated matters.
We'll certainly deal with those matters. My lord, would it assist just to briefly look at paragraph 58 of Schedule 36? It's on page 46, in the definition of tribunal. Tribunal means the first tier tribunal, or where determined by or under tribunal procedure rules, the upper tribunal. Now, I don't say that answers my lord's point, but it's...
No, it's worth making. I see that. I suppose at the risk of complicating matters, just to make clear, the first tier tribunal is a creature of the 2007 Act. It is given it is given jurisdiction by other acts. its ordinary tax appellate work is presumably, that my lord, my lady will certainly know, but it's under one of the provisions of the Finance Acts or Taxes Acts. It doesn't really matter which. But it's clearly a different set of provisions than paragraph 36.
The FTT is given its jurisdiction by a whole raft of different references in different legislation, my lord, yes.
Yes.
Returning then to the FTT rules, I was up to, I think, Rule 29, the requirement to hold a hearing, and my lord asked, do we have proceedings in the first place? I've answered that, but we'll come back to that with the additional information. Paragraph 30, sorry, Rule 30, subject to Rules 19 and 32.4, each party to proceedings is entitled to attend a hearing.
Yes.
Rule 19 doesn't actually deal with attendance at a hearing, it deals with participation. Go back and look.
Well, Rule 19 talks about proceedings without notice to a respondent.
Exactly.
So if you're right in your fundamental submission that both the taxpayer and the third party are parties to the proceedings which consist of the revenues application for approval of a third party notice, then is the starting point that Rule 30 confers a right on both the taxpayer and the third party to attend a hearing, unless one of the exceptions applies. But on the face of it, does it first start with a right?
Yes, but the right to attend is not the right to participate.
Well, yeah, that may be right, but what would be the point of attending if you're not going to participate?
Well, that's the whole point of my second argument, which is there is inherent interest in justice being done in public, and the right to go and listen and see how the tribunal deals with the matter relating to you is one aspect of that.
But so are you saying members of the public should be able to come into these hearings and listen to what is being said about the taxpayers' private affairs?
Yes, my lady. I mean,
You are.
The tax tribunal deals with private tax affairs of the great, the good, and everyone every day of the week, and it's inherent in the whole function of the tax tribunal that details that may, in other circumstances, be kept confidential or made public. So the fact that an information approval hearing might involve reference to the private tax affairs of a taxpayer is not of itself a good reason not to hold it in public. Otherwise, almost all tax tribunals.
Well, but it's a rather different, it's a preliminary procedure at a time in which it's not even clear that there's going to be any challenge by the revenue to return or whatever the nature of the investigation may be. It's a rather different proposition to say that the public can turn up for a procedure of that kind than on the hearing of a substantive appeal.
It's a little different to a closure notice hearing. So in a closure notice hearing, HMRC have opened an inquiry. They haven't concluded their inquiry. But the taxpayer goes to the tribunal and says, this has gone on too long, we want it to come to an end.
Well, I thought it was fundamentally different.
There is an inquiry.
There's an inquiry in the statutory sense in that situation, but equally here there's an inquiry, and an investigation other than the time limit rules is not very different. So
yes, but the nature, what you have to decide in again, I'm out of my territory, but in a closure notice hearing is essentially whether or not there is a ground for, I don't have the technical terms, but for finding there's something wrong in the tax affairs of the taxpayer.
For bringing the inquiry to an end.
Yes, but that necessarily involves consideration of the substantive issues. This is what we're dealing with here is an entirely investigatory process, information gathering process.
well, exactly, but the basis on which HMRC might say, well, we shouldn't have to issue closure notice is because we're still information gathering. So, I mean, my lord, the proposition was, well, this type of hearing is not a final determination of substantive tax rights, therefore perhaps the open justice rules apply in a different way or don't apply at all. My response to that is that I don't accept. I'm going to deal with them in more detail later, but by way of initial comment, there's little difference between a closure notice application and a approval of information notice in terms of the stage of the proceedings they're at. I mean, in this case, we've got both on foot at the same time, and the types of information or submissions HMRC might want to make. Now, I appreciate that tests are different. I'm not saying the tests are the same, but the sorts of points the tribunal will be hearing from HMRC as to why the inquiry shouldn't be closed, because we're still investigating, because we need all this information, and the reasons why HMRC might give us saying we need this information. There's going to be a broad overlap there. Maybe not a complete overlap, but at least a broad overlap. And so if you say, well, approval of information notice hearings are a special category where open justice doesn't apply or applies in a different way, then you have to consider the consequences of that. Does that also apply to closure notice hearings? And there could be other situations where tax rights aren't being finally determined by the tribunal, but nevertheless the FTT is hearing matters. And there is the authority in my skeleton argument that open justice applies at interlocutory stage. Now, I appreciate this is not the interlocutory stage of a final determination of tax rights, but the breadth of the principle of open justice should not be in doubt. And I think that the Haralambous case is also on point in this matter, because there the Supreme Court confirms in relation to what is, in many respects, a similar procedure in relation to criminal investigations, that open justice must apply, subject to the minimum restriction necessary to do justice in the case. So my firm submission will be that open justice applies just as much at these hearings as it does at closure notice hearings, as it does at determination of final rights.
Well, it's what happens, I'm afraid. We've distracted you from the point about whether there's a distinction between participation and attendance. I forget how we got to that point.
I was showing you Rule 30, my lord.
Yes, you were. And can I just take you back to that?
Yes.
So your submission is it, that on the face of it, subject to the exceptions in Rule 19 and Rule 32.4, both the taxpayer and the third party do in fact have a right. So this is not about the tribunal having discretion. On the face of it, they have a right to attend a hearing, if there is a hearing, of the revenues application.
On the open justice point, yes, that is...
No, I'm not talking about this. That's your ground 2 in this appeal. I'm talking about ground 1 of the appeal, which is whether there is a discretion in the tribunal. I thought that's what this case was about, primarily. But you now seem to be submitting that, in fact, there's not a discretion, there's a duty, because each party to the proceedings is entitled to attend a hearing.
But that goes back to my distinction between merely attending and actually participating.
Yeah,
so as long as it's understood that by attending I mean no more than sitting in the room and listening.
Listening, I see. And what about Rule 31? The tribunal must give each party entitled to attend a hearing reasonable notice of the time and place of any hearing. So do you say that that is a duty imposed on the tribunal in every case? Because it will be in every case, won't it? Whenever the revenue apply for an approval notice, approval of their notice by the tribunal, and there is going to be a hearing, then presumably the tribunal must give the third party and the taxpayer notice of the time and place of that hearing. Is that right?
As long as we're understood that we're talking about the open justice issue, I accept that.
No, I'm not talking about the open justice issue at all. I'm just talking about whether this rule applies. Do they have a duty to give them notice of this hearing or not?
Subject to Rule 32.4, yes, because you have the right to attend, which means no more in my submission than to physically be in the room if there is a room.
Is that right? Isn't there the right to attend? In that sense, is covered by the rules about whether the hearing is public or in private. You're effectively saying the right is just the right of any member of the public, happens in this case, you say, to be a party. That's all covered by Rule 32. I don't see in that case what Rule 30 would add. Surely the entitlement to attend, in the case of a party, is equivalent to a right to participate in the hearing. You wouldn't give someone a special right under the rules to attend a hearing if it wasn't also a right to participate at the hearing. That's, I haven't done a trawl through the CPR, but that's what we normally mean by has a party been given notice to attend, means attend so they can say what they want to say.
The reference in Rule 30 is to exclusions under 32.4, which are exclusions of up to anybody and everybody. So in my submission, the right to attend and to be present in a room is not the same as the right to participate.
It's also subject to Rule 19.
And that refers to participation, suggesting there is a difference between participation and mere attendance.
Yes, I see.
Yes, and I think you might say at page 77 that Rule 32, paragraph 3 is consistent with your submission, I think. And the tribunal may determine who is permitted to attend the hearing. And that can be, for example, they may not want a child to be present, so they can use the power in subparagraph 4D to exclude a person under the age of 18.
My lord, that
I see that.
That is right.
But you are saying, I just want to be clear, that you are saying that in what might be thought at first blush to be simply an investigation, in which, as it happens, Parliament has thought fit to require the imprimatur of a judicial body, but it's still just an investigation by the executive. But in that context, you say that the taxpayer and the third party have become parties, and therefore various consequential duties then follow, including that the tribunal must give each party notice of the time and place of the hearing, and they're entitled to attend, although not to participate. I want to be clear, that's what you're saying.
Correct. I mean, the burden of my open justice argument is precisely that, the ordinary rule that unless there are quite exceptional circumstances, the hearing must be in public, applies to these types of proceedings. That's the basis on which I make that submission.
It's my fault. For my purpose, at least, because I have this kind of mind, I find it helpful just to distinguish ground 1 of the appeal from ground 2. Because ground 2 brings in ordinary members of the public and so on. And ground 1 is about the taxpayer and the third party themselves. Right? Forget about whether anyone else can attend the hearing. And see, I had thought, perhaps naively, that the revenue don't even have to give notice that they're going to make the application. That's 2A in the Act. Right? And that they turn up, and that it's an ex parte hearing, that no one else is entitled even to know that the hearing is taking place. But you say that's just a misunderstanding of what's going on. Actually, people are entitled to know that it's taking place, and they're entitled to come and knock on the door and come in through the door, although they're not entitled to participate.
That's right, my lord, and that's why I would draw the distinction between grounds 1 and 2, as ground 1 being about participation and ground 2 being about attendance, both of
I see.
the taxpayer
Yes,
and
I see.
other persons.
Forgive me, I see.
I think it's going to be helpful to take you to some of the authorities now.
Yes, and it'd probably be helpful too if we don't ask you so many questions that I don't make any promises.
The introductory point I want to emphasise again is that paragraph 3.2a shows that Parliament, in my submission, acknowledged that an inter-parties hearing might be appropriate. Now,
Sorry, how do you get that from that provision?
because it says maybe without notice.
But that's about notice given by the revenue. It's got nothing to do with the tribunal.
Well, but the case...
Even if the revenue gives notice, it doesn't necessarily follow that there has to be a hearing.
Well, it does under the FTT rules, because every case requires a hearing, subject to tightly confined circumstances. I think that's Rule 29. So there does have to be a hearing.
Well, sorry, did I say just a hearing? I meant an inter partes hearing.
But so the proposition is, if HMRC have decided to make the application on notice, does does the respondent, the recipient of that notice, have a right to participate? Well, in that case, yes, because the HMRC themselves have decided this is not an appropriate case without notice. The point of my
But I'm sorry, you need to distinguish between the notice given by HMRC and whether there should be an inter partes hearing. It doesn't necessarily follow from the fact that notice is given that there should or should not be an inter partes hearing. It depends on the statutory scheme.
Can I take you then, please, to Asif? It's behind tab 5 in the authorities bundle. And this was a case where HMRC suspected VAT fraud. They applied for a third-party information notice under the VAT Act on an ex parte basis. The taxpayer contended that the order should not have been sought ex parte. I'd ask you within Asif to turn to page 134 in my bundle. Bottom right.
Yes. Which part?
Besides B, we've been helpfully referred to a number of passages in both reports. These are the reports leading up to this introduction of that legislation. And I note paragraph 9.23, the Keith Committee expressed the view that investigation of tax fraud is inherently more difficult than investigation of mainstream property crime involving similar amounts. There are fewer complainants. Mr. Elvin, who's appeared for us, for the commissioners before us, places considerable reliance upon that analysis because he contends that in order to meet the special problems of revenue fraud investigations, the Keith Committee made recommendations which Parliament enacted in the form of Schedule 11, and that the resultant statutory powers should not be construed as if they form part of some more general statute with a wider application. Then if we go over the page, please, to 145D. I ask you to read from the paragraph just above D down to the end of that paragraph.
Certainly. Yes.
And if we continue on into the paragraph just below H, you'll see the reference there to section 15.3 about reading words in.
Yeah.
And then finally, over the page, the entire paragraph under application in this case, please.
Just forgive me, Mr. Firth. Just to be clear, this is an application for judicial review, although it's at the Magistrates' Court.
Because they're challenging the grant of the information notice.
And who were the applicants for judicial review? Were they the subject of the third-party notice? But not taxpayers, is that right?
I think it was a taxpayer notice in this case, wasn't it?
I see. Right.
I'm not sure, but I think so.
Oh, I see. Right. I may be missing something. Forgive me, Mr. Firth. Speaking for myself, and with great respect to the divisional court in this case, I'm not sure myself that as a matter of statutory interpretation, a provision which says that an application can be made without notice has the consequence that often it should be made with notice. And that in every case you have to consider whether it's appropriate to proceed in that way, bearing in mind that the balance is always in favour of proceeding inter partes. And where do they get all of that from, with all due respect to them?
Well, we'll see a similar point about the court being able to control the procedure in Wiseman. Where do they get that from? Well, it's, in my submission, the difference between shall proceed without notice and may proceed without notice or apply without notice is a real difference. And we'll see it in Haralampus. That case said shall be made without notice. So if Parliament has gone to the effort of saying, well, actually, we're not going to say shall, we're going to say may, some effect must be given to this. The question is, what is the effect?
Well, what I'm suggesting to you, maybe the effect, is simply that they are not acting unlawfully if they do not give notice. So in other words, they are permitted by law to proceed without giving notice. That's it.
But then that must also accept that Parliament didn't see any inherent problem in proceeding with notice. So the argument against...
That's a matter of discretion for them.
Well, that's a point that this case deals with and the case with Wiseman deals with. But the argument against me is we can't possibly have an inter partes hearing here or any element of participation because it undermines the statutory scheme. And Parliament has only said, well, it may be without notice. That takes a big support away from that argument because, well, Parliament could have said must be without notice, shall be without notice. But in saying may, Parliament's clearly envisaged, well, actually, we're not going to be definitive about this. Then the question for the court is, well, what is the effect of that? And the effect, according to ASIP, is that, well, both HMRC and the person to whom the application is made must consider whether it's appropriate in that case to proceed without notice.
But I'm finding it difficult to understand why you see an inextricable linkage between whether or not notice is given and whether or not there is an inter partes hearing. 2A simply talks about the notice that the revenue may or may not give. It says nothing about an inter partes hearing.
I would rely upon the ordinary understanding of what without notice proceeds, and also Rule 19, my lady, which explains the effect of applying without notice. It says without notice means without the right, you disapply the right to participate.
Right.
So
you say as a result of the rules, not as a result of your construction of the legislation.
Well, both, my lady, because the rules are doing no more than setting out what I would submit as an ordinary understanding of something being determined without notice.
I'm not sure that's right at all. I'm sorry to distract you by another context and tell me if it's not helpful. But in the Crown Court, for example, a PII application is sometimes made, but notice is given. So where the public interest does not require that even the fact of making the application must be kept secret, it's not unusual. The defence are told by the prosecution, tomorrow afternoon, we're going to ask the judge to make a PII ruling. That doesn't mean that then suddenly the hearing before the judge becomes inter partes.
Well, my lord is putting, I think, a slightly different point, which is what is the effect of it being with notice? Does that give you a right to participate? Answer, my lord is saying no in that instance.
Yeah, but what I'm suggesting is that conceptually, therefore, as a matter of law, there is a distinction between the question, does a party give or not give notice, to the other party that a hearing is going to take place from a different question, which is whether the hearing can be inter partes, or perhaps must be inter partes.
But if I see my Lord's point, if that's right, then Schedule 36 tells us nothing about participation. It leaves it all to the FTT rules. And you apply the ordinary FTT rules, but the FTT rules have something to say about what without notice means. So I think we end up in the same position. So that's Asif. The next case I want to show you is just very briefly, a few passages from a first-tier decision called Skelly, where HMRC appeared to agree that the tribunal had a discretion. That's behind tab 12 in the authorities bundle, please. And it's paragraph 52 on page 294. Ms. Nathan is counsel for HMRC. Can I ask you to read, please, paragraphs 52 and 53 and 55.
I see that at paragraph 53 there's reference to a judgment of my lady in Derry. But I may have missed something, I'm afraid. All I'm seeing in these passages is the point that my lady has really been putting to you at this hearing, namely that this is all about whether the application can or may be without notice on the part of the revenue. It says nothing about whether the hearing can be or must be inter partes.
Well, my lord, this goes back to the point I think you just raised, which is, well, if without notice says nothing about participation in the hearing, Schedule 36, then Schedule 36 says nothing about whether a hearing should be with inter partes or not. And then you're just left with the FTT rules. But in my submission, that would be an erroneous reading, because Parliament must be understood to know that this Schedule 36 links into the FTT rules, which are the only set of rules governing the FTT procedure. And Rule 19 specifically says what without notice
All of that I understand. All I'm suggesting, and I may be wrong, is you said the revenue had made some concession which assists you in the present appeal. I'm not seeing what concession they made that assists you in the present appeal.
Well, it's both the concession and the tribunal accepting it was correct. It's that if you read 52,
That there's discretion to be exercised by HMRC.
sorry, and 53, Ms. Nathan also accepted that paragraph 328 confers a discretion on the tribunal whether to hear an application ex parte or on notice.
I see. So that must mean, on notice there, must mean inter partes. Is that right?
Yes, I mean, it
That's
would be
what
odd
you're
for an
saying.
FTT judge to be using those phrases without some regard to what the FTT rules say about what without notice means.
I see. So the submission is that paragraph 32A confers a discretion on the tribunal whether to hear an application inter partes. That's your submission.
That's one aspect of it, yes.
I know, but based on
Based on this,
yeah,
yes, my lord.
yeah.
And that's
I-
confirmed again at 55. Parliament has given discretion to HMRC and to the tribunal. And then paragraph 60 through to 62, please.
Sorry, I'm, oh yeah, I can't find the passage.
Sorry, 60.
Through to 62, please.
So read through from 55 to 62.
Sorry, no. So 52 to 55 we just
Yeah,
hopefully read, and then 60 through to 62 is a separate chunk to read, please. you see there, my lord, particularly 61, that it's understood that what's being talked about is without notice or inter partes in some way.
Yes?
Could we then go to Wiseman in the House of Lords, which is the decision that the court helpfully referred us to? That should be at the front of your authorities bundles, unless you provide yourself with a separate copy. Yes, but in the front of tab 1. This case concerned, as I've already said, approval of HMRC's decision to invoke a set of anti-avoidance rules. And you can see from the legislation is quoted in footnote 1. It's quite lengthy, but
I'm so sorry, Mr. Firth. I missed where you said Wiseman was.
it's in front of tab 1, my lady, so
Thank
just
you.
behind the index.
Yeah, thank you.
So the legislation is fairly lengthy. It's set out in footnote 1. In essence, HMRC were going to invoke this set of anti-avoidance rules. They had to give the taxpayer notice of that. The taxpayer could write back and provide a statement saying why it shouldn't be invoked.
Can we just see the particular?
Yeah.
I
It's,
applaud you not making us read it all, but which are the particular provisions?
could I ask you
of
to
notice?
look at G on the first page, please, and read from 4 and 5, please.
Yes, thank you.
The issue in the case, you can see just below A on 298, is that the taxpayer requested to be represented by the council at the determination, and to be given copies of the commissioner's certificate.
So that's participation, not just attendance.
Correct.
Yep.
The House of Lords said, and if I can just summarise this because I want to show you the caveat, they said in the particular facts of that case there was nothing to suggest the procedure was unfair, and therefore there was no reason to interfere with the decision. What I do want to show you, if I may, is if we go to page 308, please.
Yes.
And the most important paragraph, in terms of what the position I'm making, is the final paragraph of Lord Reed's speech.
Yes.
To similar effect is if we go to Lord Morris's speech, please, and read from just below F to the end of the judgment,
Which page? I see. It's
309. finding Lord Wilberforce, please, on page 320, from G to the top of the following page.
The context of the statutory scheme in this case required the revenue to set out the facts and matters, the facts and circumstances upon which their opinion was based for the taxpayer. They had to set it out in a statement, and the taxpayer was entitled to counter it.
There was an initial notice to the taxpayer saying we intend to invoke this.
Yes.
Then the taxpayer had the opportunity to say, no, you shouldn't invoke this for these reasons.
Yes.
That was a taxpayer statement. There was then a counter statement which the taxpayer didn't see, but which went to the tribunal, and that was part of the problem from the taxpayer's perspective. We don't see that. We don't know what's in there. There could be something mistaken in there that would need to be corrected.
Thank you.
Is this an accurate summary of what the House of Lords decided there, that in the circumstances there was no breach of natural justice, so fairness did not require what the taxpayer was contending for, but you say, importantly, the House of Lords recognised that there was always a discretion in the part of the tribunal?
That's precisely what I say is the takeaway from this House of Lords decision.
And the discretion in that case was not to have an inter partes hearing. It was a discretion to seek further information from the taxpayer on particular points.
Well, I mean, I wouldn't confine it in that way, my lady. If you look, for example, at Lord Wilberforce just by H, to take appropriate steps to eliminate the unfairness. So I don't think the House of Lords were prescribing that this is the only thing you can do. They're saying you do what you think is necessary to eliminate the unfairness, and that may well be an exchange of written submissions. It could go beyond that, but I don't think they were being prescriptive. And that is the same point I'm making in this case, that I'm not saying that the answer to, if the tribunal is satisfied, well, there might be justification for some level of participation. That may not be an inter partes hearing. That may be saying, well, this point is something we need to hear more on from the taxpayer. Let's have an exchange of submissions on it. So the level of participation is in the tribunal's hands. The crux of my argument is there is the power for the tribunal to say what it needs to do its job properly. Because if you look at the decisions, why are they saying this? Why are the House of Lords saying this? Because they recognise that ultimately, the sort of, why is the tribunal there? Hopefully to make a correct decision. And if there's something that might assist the tribunal believes will assist it in taking a correct decision, and there's no reason why that shouldn't happen. And we certainly shouldn't read the statute as prohibiting that. And that's all I'm saying in this case, because when you look at cases like Coons, the House of Lords are saying clearly that there's the overall purpose of this is to sort of make a correct decision, get it right, and that same overriding consideration permeates all these situations. And if if the tribunal feels, well, this might assist us in achieving more effectively our objective, then why shouldn't the tribunal be allowed to permit that?
So there are a range of options. You're not suggesting an inter partes hearing is the only means of remedying what you say is a natural justice failing here. The tribunal could say, Mr. Officer, I'm not satisfied about this aspect of the document that you've produced. I'd like to know what the third party says about this particular aspect.
Exactly.
And ask for written representations on that point.
Exactly. So if it was a specific thing that the officer has said that the tribunal thinks will hang on, because they often will have been provided with a summary representation from the taxpayer, they might say, well, actually, that doesn't square with that. There must be more to this. The tribunal, in my submission, has the power to say, HMRC, we need to know, I want to know a bit more about this. I don't want an inter partes hearing, but I want you to cut and paste that section of what you've written, send it to the taxpayer, give them 7 days to respond to the tribunal or to HMRC, and take it from there. Because
from memory, and I may be wrong about this, in Cotton, something along those lines happened. There was an original application that the judge adjourned because he or she, I can't remember, was not satisfied, and further information was sought. I can't remember now From whom?
My lady, that is correct. There was an application, there was the examination, the judge expressed concern about certain points, and so sent the revenue away to address those points. Further written submissions went in, I think, as well, and the officer then went back to the judge with the answers.
On an ex parte
On an
hearing?
ex parte basis, it didn't involve any direction to ask anyone else
Yes.
about it. It was come back with the answers as to why you say this is right.
Yeah.
And you say, Mr. Firth, that it follows from the existence of that power that there must also be an obligation to consider representations made by the taxpayer for the exercise of that power.
Yes, if the taxpayer makes an application to the tribunal, asking the tribunal to exercise a power that would allow it to participate in some way, then I can't see any basis in which the tribunal could say, well, we don't need to even consider what you've said. That would be quite unusual, my respectful submission. And it's not...
And if they decline to do so, well, let's just take it in stages. If the taxpayer writes and says, well, it could say one of two things. It could say, here are some further facts, which doesn't look as though we're worried you may not have been told. Or says, there's a lot we want to explain to you, but we want a hearing. And the tribunal says, no, we're not going to consider those facts, or no, we're not going to have a hearing. That's an appealable decision or a judicially reviewable decision?
So if the tribunal accepts it as a power and then decides to exercise it in a particular way, and the taxpayer says there's an error of law in the way the tribunal has exercised that,
Yeah, they might just say it's perverse.
then I would say that there's a right to appeal that because there's an error of law in the tribunal's decision and no exclusionary rules. So, yes, and that is not dissimilar to the way we've got here, which is the tribunal at an earlier stage in that logic saying we don't even have the power.
Right, no, quite, this is...
Sorry.
Forgive me, if the tribunal has the power, which you contend, then would certain things follow as a matter of fundamental public law? One is that they must consider exercising it.
That must be right.
And before, I think the second thing that follows is that before they decide whether to exercise it or not, they must consider any representations which have been made to them about whether they should exercise it or not. I think you said that to my lord, yep. Yep. But what if the taxpayer doesn't know at this stage that any of this is going on? So does the tribunal, before it considers exercising its discretion, also have to inform the taxpayer and invite representations?
I wouldn't say so, no. I mean, you can compare it to a situation where there are tax proceedings that concern somebody who isn't the actual taxpayer, and from time to time the tribunal receives an application to intervene and addresses it and deals with it. It doesn't mean in every case the tribunal has to actively consider should we be inviting people to intervene. There is a power. It is up to, well, there's two possibilities. Either the tribunal of its own initiative might say, right, well, there's something in these papers that requires more explanation. I'm going to deal with it in this way, and that's one of the things the House of Lords was considering in Wiseman. Or the taxpayer who will know about the fact of an application may ask the tribunal to invoke it, but I don't say the tribunal has to actively go out and try and find people who might want to intervene or make representations. I don't say that.
And would you accept that there's a difference between inviting submissions or seeking further information on particular matters that occur to the tribunal in the course of an approval hearing, and having the taxpayer present in circumstances where he or she may then hear things that the revenue may not wish them to hear because there are confidentiality issues in relation to other taxpayers, or because there are matters around the investigation that the revenue doesn't want to reveal its hand.
Yes, that will be in the discretion of the tribunal. Once it's decided, right, there's something we need to know a bit more about it, then how do we best deal with that? And if the concerns that my lady raises exist in relation to that case, then it may well be that the tribunal decides the most proportionate and efficient way of dealing with this is not to invite the taxpayer or the third party along to a hearing, but to say, right, this is the specific point that we want to hear a little bit more about. What do you have to say about that? And it's a written procedure. That would be entirely possible.
But I thought your case was that it followed from the existence of the power in the tribunal to seek more information, that there was an obligation on the tribunal to consider allowing participation.
The question from my lord was, if there's an application, do you have to consider it? I think that's how I understood the question. My answer to that was, yes, if there's an application, you have to consider it.
That wasn't his question.
Equally, I said, does the tribunal have to actively go out and seek people who might want to participate? My answer to that was no.
My Lord Justice Underhill put to you, were you saying that it followed from the existence of the power in the tribunal to seek more information, that there was an obligation on the tribunal to allow participation in an appropriate case? And you said yes. But do you not...
So that's a non sequitur, that the existence of a power cannot lead to an obligation to exercise that power.
I was in a way more interested in your answer. So sorry.
Sorry, no, go on.
To my Lord Justice Singh's question. Does the fact that the tribunal have the discretion mean that in every case it has to consider whether it should exercise that discretion? And you said yes.
It's no different to the question of jurisdiction. So the FTT must stay within its jurisdiction. And in principle, if something arises that causes the tribunal to question its jurisdiction, it must investigate and decide that point. But that doesn't mean that in every case the tribunal has to have a passage in its decision and actively go through the motions of saying, right, we have jurisdiction for these reasons. Similarly, in dealing with a third-party notice, the tribunal will be aware that the taxpayers received a summary of the reasons why HMRC think the information is required. And if they've heard if nothing's been received from the taxpayer suggesting that there's any reason why any level of participation might be appropriate, unless something jumps out at the judge from the papers, then the judge hasn't erred in law in simply going on to consider the application. But that's a very different point to my point, which is simply saying where there is an application, you should consider it. And equally, based on the House of Lords, the judge may, of his or her own volition, decide there's something here that requires further consideration. But these are the same points that would apply to what the House of Lords was saying in Wiseman.
Can I just be absolutely clear what it was that triggered all of the litigation, which has now reached us? Was it your application, which starts at page 125 of the core bundle, behind tab 10, where the applicants applied for a number of directions?
Yes, because we got notice that the application...
No, but I just want to see what the directions were that you were seeking, and therefore, so we're not necessarily having the discussion in the abstract, as it were, but see exactly what it was that the FTT was being asked to direct. And was it this A, B, C, and D? Page 125 and 126?
Yes.
Yeah. So A was that notice, the application should not be heard in private. And that's really going to be subject to your ground 2 in the appeal. Taxpayer applicants and third parties should be given notice of where and when the hearing is to take place. They should be given a summary of the representations, and they should be given the opportunity to make representations. But is this right, that what you're submitting to us is that you were not necessarily seeking a direction that there had to be a hearing, and if there was a hearing, that it had to be inter partes?
In this appeal now?
No, in the application for directions.
In the
Just
application?
want to be clear what you were actually asking the FTT to order.
Well, it's D. I was asking for the opportunity to make representations, but that's a bit of a separate point. What the first question is there a power? The tribunal said no, not considering this. The taxpayer can suggest, A, that you should exercise the power and this is the way you should exercise it. But if you disagree with the second part, doesn't mean you sort of say, well, that rules out any.
Mr. Firth, I'm sorry. Mine is much more basic question. It's just to understand what you meant when you applied in D for the opportunity to make representations. Did you mean at an oral hearing?
Thinking back then, I without reading the whole application again and thinking about that one.
But surely para. Oh, I see now. I'm confusing myself now. The first line of para 2, the applicant's request that the above applications be dealt with at a hearing.
Yeah.
That means the applications for A to D. Yeah,
Yeah.
sorry,
Yes.
that's a red herring. My fault.
No, I see that.
But
Well, 26, paragraph 26 says nothing prevents the FTT hearing representations. So that's not reading them, hearing them.
Might mean entertaining them, doesn't it? I mean, the trouble with audi alteram partem doesn't always mean that you actually have to hear with your ears.
I may have misunderstood, Mr. Firth, but certainly the way to date I had read both the FTT judgment and the UT judgment was that they understood that what they were being asked to decide was whether they had a power to hold an inter partes hearing.
that's because the points tie in together. If there is this power, as referred to by the House of Lords and Wiseman, to permit participation, at its upper end, that might include an inter partes hearing. At its lower end, it might be written submissions. The FTT and the Upper Tribunal have rejected the very existence.
In a sense, the question whether it's a hearing is, I understand your submissions now, or I'm not sure I understood them this way before, is that what you are essentially asking for is to have your submissions considered or entertained. It would be a matter of case management, whether that were done by having them in writing and considered, or whether you should be entitled to attend a hearing. I see, forgive me for not having dropped this basic point. Does that always have to be a hearing of the approval application by the revenue? Or can that itself be a paper procedure?
In my submission, the rules require a hearing, and I believe in practice, and I think this is stated in the judgments below, in practice there always is a hearing.
Yeah.
Because the judge will ask questions of the HMRC officers.
Yeah, so certainly, quite possibly incorrectly, I had understood that the understanding of both the FTT and the UT was for that reason, that what they were being asked to decide was, can that hearing take place on an inter partes basis, or are you required to conduct that hearing on an ex parte basis? And I thought, perhaps wrongly, that that was the fundamental issue of law which has come before this court now under Ground 1.
That was my
With the
understanding
grounds,
as well.
The conclusion against me is that there's no power to permit any participation, because that's contrary to the purpose.
So the conclusion of?
Well, that's the conclusion of the FTT and the Upper Tribunal.
Can you just give us the paragraph references where it says any participation?
Paragraph 54 of the Upper Tribunal decision sets out key issue before us is shortly stated. We must decide whether the FTT had the power to make the directions the taxpayer was requesting.
Yeah. But how do they conclude? Forgive me.
I'll allow my lord to go first.
Yes. It's certainly paragraph 83 on page 80.
So if I can refer you to 75, Mr. Firth argues that the courts have already decided there was an exception to what might otherwise appear to be an absolute exclusion of the taxpayer's right to make representations to the FTT in connection with the rule. Since some exceptions exist, other exceptions are possible, and the FTT says that's not an exception. It's just a practice.
No, forgive me, Mr. Firth. What I was drawing attention to was what I understood to be the kernel of what the UT has decided and is therefore under appeal to us, which appears, I think, at page 80, in paragraph 83, that about 6 lines up from the end of that paragraph, we have come to the clear conclusion that by necessary implication, the scheme of the legislation in Schedule 36 excludes the possibility of information notices being approved following an inter partes hearing. Now, you may submit, and perhaps correctly submit, that I have misunderstood what they were deciding and that they were not simply deciding that issue, and your appeal concerns a broader point, in which case, please forgive me.
Well, my submission does concern the broader point because that's the way it was argued and that's the way my submission is decided. I recall and looked over my submissions and preparing for this hearing that I made the same submission, that it doesn't necessarily mean the full sort of adversarial.
Can I just direct you to the first sentence of that paragraph, where the Upper Tribunal described the taxpayer's request as a request to be permitted to participate in an inter partes determination. Did the UT misunderstand and get that wrong?
Well, if there's submissions from the taxpayer, that is an inter partes determination.
Yes, I mean, have I understood your position to be this? That your submission was, at its most fundamental level, that you be allowed to participate in the determination, i.e. to make representations which would be taken into account for the purpose of the determination. In practice, everyone proceeded on the basis that that would be in the form of a hearing, because everyone knew there was going to be a hearing, because there has to be one, or in any event there always is one, and that was the obvious way of doing it. But that was not the principle. The principle was that you should be entitled to participate in the decision. And if that were done by way of entertaining, it could fairly be done by way of entertaining written submissions, but not asking you to not inviting you to attend the hearing, that would be perfectly acceptable in principle. You might, in a particular case, say it wasn't the right way to proceed, but that would be another matter.
Yes.
Have I got that right?
I think so, Lord, because the Upper Tribunal didn't say, right, we rule out the possibility of any oral representations at a hearing. That if you want, you might be able to make written representations, go and make an application for that. I don't think either my learned friend or myself understood us to be arguing solely about the question of whether it would be being present and arguing the matter at an oral hearing. It was the bare existence of a power to make representations in some way, and that could be an oral hearing, that could be in writing. I don't read the Upper Tribunal.
I mean, it's fair to say, isn't it, that there are ambiguities, which perhaps this is teasing out about our normal use of phrases like ex parte. I mean, I'm old enough to remember when we used to talk about interlocutory injunctions ex parte on notice, which seemed bizarre, but what it meant was that you couldn't, there it had a very particular meaning, was that there wasn't time to make a formal application, but you had to give notice to the other party. And clearly the notice was so that they could turn up and do something about it. They might not have time, because these things are often done in a few months. But in one way and another, they would be entitled to be heard. And that was still an ex parte procedure. That's not quite what we're talking about here, but it's an illustration of the ambiguity of a lot of these phrases. And your essential point is that you have the right to be, well, I'm going to say heard, but it doesn't necessarily mean heard with the ears, on in this type of application. Or at any rate, you have the right to ask to be heard.
The right to ask the tribunal to exercise its power to hear from us, how it hears from us, to be decided.
Can I just, forgive me for pursuing this, can I just be clear? Everyone appears to have proceeded on the assumption that there would be a hearing. So the revenue would be heard at a hearing, at an oral hearing. Are you conceding that if the revenue are to be heard at an oral hearing, that you need not necessarily be, that you could be told, well, you can make some written submissions, and we'll take those into account?
I'm accepting that that's one way the tribunal might decide to exercise its power, yes. It's not an all or nothing situation whereby the tribunal has to decide, right, you can either attend, make full representations in a full toing and froing like this hearing, or you get nothing. And that would be an odd dichotomy to set up, given that there's clearly means of making representations and participation falling short of actually attending the hearing.
But earlier, Mr. Firth, you said to us that although there's no express provision in Schedule 36 for the taxpayer to make representations, there is an express provision for the third party, and the taxpayer is at liberty to make written representations, and I think you even went so far as to say in practice the revenue receives those regularly and puts them before the judge. So I'm now at a bit of a loss to understand what we're arguing about, because I thought you were saying that that happened in practice in any event.
That does, but we don't get to see the HMRC submissions to the tribunal. So the point would be, if there's something, take the Wiseman case where the example is of, well, there's something that might be mistaken in the HMRC revenue representations. Now, we don't know what's in those representations. We have let's say a suggestion that something might be mistaken in those, and we want the tribunal to tell us if that's, well, we want to know if that's happened and be able to make a representation. So we make an application to the tribunal saying, this is the concern we have. We would like you to exercise your power to permit some level of participation so that we might deal with this point effectively. And then the tribunal will have to look at it and say, well, actually, yes, I can see that concern exists in these submissions. So HMRC, provide that paragraph or those paragraphs to the taxpayer, and they've got 7 days to make written submissions on that paragraph.
So now you're talking about disclosure of the revenues submissions, not just a right to make representations.
Well, as all the cases on this say, the right to be heard without knowing what's the case against you is fairly worthless. So it would be up to the tribunal to determine the level of participation in the sense of, this is the point that concerns us, you must provide that to the taxpayer, and the taxpayer gets a right to respond.
But that's not what you were asking for here. You didn't say in your application, we're concerned about a particular matter and we want disclosure of the revenues submission so that we can make submissions either orally or in writing about it. You were simply asking for the right to participate, and as I understood it, at an oral hearing. You say no, I'm wrong about that.
The-
Because you were free to make submissions. You've told us you were free. It's a freedom, you said.
No one can stop you writing to HMRC,
Yeah.
surely.
And in
But
practice,
frustrate them from time to time.
and in practice, HMRC put those submissions before the
Yes.
tribunal. That's certainly been my experience.
Yes.
Yeah.
And so if the concern is that something might be mistaken in the submissions that we don't see by HMRC, then that the tribunal might address that either in a very specific way, or if it doesn't have wider concerns, might address it
But I'm at a loss to understand what we're arguing about now. If the reality is all you want to do is be able to make submissions in the first place, which you were able to do as a matter of freedom.
My lady, that's why we must not conflate the question on this appeal, which is the power, with the question of how it should be exercised in this case, because as was aired at the very beginning, we never got to the stage of saying, sort of having a hearing and having evidence and saying, right, well, that's the concern and this is the way the power should be exercised. We didn't get that far because the power was said not to exist. So the question for this court is there a power? And then if there is, then the tribunal's got it wrong, and you send it back to the tribunal and say, right, there is a power. Now you must consider.
Well, it's not quite as simple as that. You've got to say a power to do what? And I think what we're testing you on is whether your proposition below was, is there a power to direct that we attend the hearing? And I think what you're saying is that may well have been, in practice, how the power would have been exercised if it was exercised at all. But the essence of it was that you should be able to see what the other side had said so as to be able to answer it if necessary. The most efficient way of doing that is to turn up at the hearing and hear it being said and then answer it. But there would be other ways of dealing with it. One would be for it to be written down in advance and you to see it. That's slightly unsatisfactory, frankly, but then you could put in an answer to it so that by the time the hearing took place, they would see both what HMRC had said and your answer to it. That might be rather unsatisfactory because the hearing, the tribunal might then want to, as it were, tease out the differences. Or it could be done after the hearing, another one, which is more the Wiseman and Bournemouth approach, I think, which is, well, we see what the revenue said, we've seen what your responses were in the earlier correspondence, and there is something that worries us, and we will ask about that on paper. I think you're saying these are all different ways of achieving, or in which the power might be exercised.
Exactly.
But it's not as such a power to admit you to the hearing. It's a power to obtain your representations where they feel it necessary to do so.
And in such a form as they see to be most efficient and conducive to the overriding objective in that case. Exactly.
But it's pretty clear everyone seems to assume below that would be in the form of attendance at the hearing. But certainly we can see the Upper Tribunal assume that.
Yes, certainly that was, yes. But equally, the fact if the tribunal says, well, we don't have power to permit you to attend the hearing, you would expect, but accepts it has power to...
It'd be very odd if that were the case. I think it's all or nothing, isn't it, for you? That the power, either the position is that this is meant to be a strictly ex parte procedure in the sense that you only hear from the revenue, subject to the provisions of seeing the prior representations and respond. Or there is a power to do whatever is, to do something more to allow the respondent to, to allow the taxpayer to make further representations.
It is...
Perhaps that's more to say it's all or nothing from Ms. Anderson's point of view.
It's all or nothing in the sense that either, yes, in that sense, but that doesn't necessarily decide that just because you have the power to permit attendance in an oral hearing doesn't mean you'll exercise say that's the way participation should take place in this case. You have the power to do it, but you decide not to do that, and you say written submission. So it is all or nothing in the sense that the tribunal either has the power to permit that or it doesn't. And I'm saying it does have the power to do that. It's not all or nothing on the specific facts.
No, I understand. Right.
Forgive me.
Yes, of course.
I'm sorry to labour this point, but it does seem to me to be something of an air of unreality about all of this, because one of the specific directions that you were seeking at page 125b was notice of where and when the hearing would take place. Was that just out of sort of academic curiosity?
Well, you've got to bear in mind our second ground, my lord, which is we want to attend the hearing even if we can't participate.
Yes, I see.
The taxpayer is perfectly entitled to ask the tribunal to exercise the power in one way, and the tribunal might say, well, we see your point, but we're not going to exercise it in that way, we're going to exercise it in a different way, some lesser way. So the way the original application is framed, I would suggest, is not determinative of the question before this court.
Yeah, paragraph A, it might be thought, dealt with that point. A direction that it should not be in private to the exclusion of the applicants.
Yes, but equally you need to know, or you'd like to know where and when it is, if you're going to exercise your right to attend a public hearing.
Yes. You see, because I had, no doubt, naively thought that what this is all leading up to was that we want to know where and when the hearing is going to take place, because we want to be there so we can make oral submissions, because otherwise you'll be hearing one side only.
Well, the argument on the first ground is whether there's the power to potentially order that. You're not concerned with whether to order that in this particular case. On the second ground, I'm asking simply for the right to be there and listen, not to say anything, not to counteract what HMRC say, and that's the open justice issue.
An analogy might be, although it happens less than it used to, on a permission application to this court, it's sometimes called into court, and the Lord Justice, Lady Justice may say, the respondent should attend, but the extent to which they'll be permitted to participate will be in the discretion of the court at the hearing. And that really means I want to have you there to ask you questions if I want help, or if I think there's something on which you should be given the chance to deal. Not sure where that goes, but it's an illustration of the sort of flexibility which is possible in terms of what you might call participation.
Correct.
My lord, I don't know if this is helpful, but there were no assumptions here. On the very first page of the Upper Tribunal's decision, you can see that it talks about what was before it, and you can see that it talks about or perhaps page 60, paragraph 13 is quite clear. There was an appeal against Judge Poole's determination about the adversarial hearing application on the papers, and that's how it was put all the way through, that what was being applied for was an adversarial hearing.
Well, thank you. We could have dealt with that in reply, but I think it's sensible for you to deal with it now. I'd forgotten that phrase had been used, but it had, and that does suggest that whatever subtleties you may now introduce into your position, the actual forensic position was there ought to be an adversarial hearing.
Yes, they defined that phrase at paragraph 8 on page 59, just so we can all be clear exactly what they meant. And as I read it, what they were seeking there to do was summarise the directions sought in the application of 8 May 2018, which is the document we've been looking at page 125.
Yeah, and I've just brought up my skeleton argument. And one of the points I made was those exceptions may well be tightly controlled and limited in scope, but the FTT was wrong to favour its discretion to consider that some level of participation should be permitted. This goes back to the same point I made a moment ago, which is the taxpayer can put their case at its highest and say, actually, we think participation in an oral hearing in an ordinary adversarial way is the right answer in this case. And if the answer to that is no, there's no power, that shuts it down. But if the answer is, well, that's not appropriate for this case, but something less is the right answer to deal with your concern, then the tribunal should do that. It's the point I made earlier, the existence of the power to grant participation along the spectrum is all or nothing.
But if you don't argue for it, it's difficult, isn't it, to come along and say that the tribunal erred in law in not granting it to you. This is an error of law appeal.
Exactly, and the error of law
But
is saying we have no power.
No power to grant you the adversarial hearing you're asking for.
Exactly, and that's my Lord's point a moment ago, which is, I do say there is a power. It's not for you. It's not for this court to determine whether it should be exercised in this case by way of an adversarial hearing. That's not before you. But I do say there is a power to order that sort of oral interaction at an adversarial hearing along the spectrum.
Well,
it's saying that the tribunal has the power to order an oral hearing or to order or written representations does not mean that if I apply for one and the tribunal says we have no power, then it's wrong about saying it has no power, then I'm barred from a remedy. The point is, the existence of the power may be all or nothing, but how you apply in a particular case is not all or nothing.
I'm sorry to pin you down, or try to pin you down, if you'll forgive me. I just want to be clear exactly what is the issue of law that this court has to decide on your submission under ground one. Is it the following? Does the FTT have the power to direct an oral inter partes hearing?
That's one way of putting it, because if it does have that power, and I'm saying it does along the spectrum.
Well, that's why I'm sorry to press you on this, but that's clearly what the Upper Tribunal thought they were deciding. That's their summary at paragraph 8, as it seems to me, at least, on a fair reading. It wasn't some kind of abstract legal question, but whether those specific directions were within the power of the FTT. That's what they understood under the compendious label adversarial hearing application.
That must be right. If I make an application for these 4 directions, the issue before the tribunal is, do we have power to grant those directions?
Yeah.
And the tribunal said, no, we don't have power to grant that. And that's the question of law before you. Yeah. Was it right to say it doesn't have power?
Yeah, and that's why, if you'll forgive me, I will try to pin you down to this, that the question of law is, and tell me if this is wrong, because we need to be clear what it is we're being asked to decide, what we have to decide. Do we have to decide, does the FTT have the power to direct an oral inter partes hearing?
That is, yes, that's part of the broader question of, does the tribunal have power to permit participation? And in my submission, if it has the power to permit participation, it does have the power to permit an oral hearing, but equally it has power to grant something less than that.
Thank you.
Right.
I'm bearing in mind the time, and the fact my learned friend obviously has to have a full opportunity to set out her case. So I'm going to, if I may, move next to the Morgan Grenfell case and then the Derring case, and make my submissions in those cases. I was going to talk about Coombs but I don't think that's necessary. If we can go to instead Morgan Grenfell in the Court of Appeal. And that should begin on page, it's behind tab 7, page 171.
(171) is the divisional court. Is that what you wanted us to look at?
Mr. Justice Blackmore is sitting in the Court of Appeal. It's sort of odd, I think, that we have the Lord
Oh,
Justice
quite right. I'm so sorry. Yep.
sitting in the High Court and then a Mr. Justice sitting in the Court of Appeal. But
Quite right.
There we are. It's paragraphs 40, you see it's 47 onwards, a right to be heard question mark. The key paragraphs, if I can ask you to read them, are 49 and 50.
So which pages are we on?
We're on page, it's bottom right, page 185.
Yeah.
If you want to see the introductory heading, it's on page 184.
Thank you. Which of the paragraphs do you want us to read?
49 and 50, please.
Yes, it's a judgment of the court, isn't it? Yes.
So the reasoning behind the conclusion is, and it's relating to predecessor legislation, is that it's based on the risk of compromising the investigation. And the underlying assumption, well, the fundamental basis, in fact, is that the taxpayer is not allowed to know anything about why HMRC are asking for the information notice. Because if you read paragraph 50, by F, it says there are only two logical outcomes if these imperatives clash in a face-to-face hearing. Either the taxpayer will learn nothing, or it will lead to accidental disclosure of material the inspector doesn't want the taxpayer to know. Now, if those are the only two logical possibilities, then it's excluding the possibility in between that there's an inter-parties hearing at which materials that the inspector doesn't want the taxpayer to know are not dealt with in that hearing, dealt with by closed procedure perhaps, and therefore something would be achieved. So the fundamental premise of this paragraph is that the taxpayer is not allowed to know anything about why HMRC, because that's the only way it can be right that there's only two logical outcomes.
I'm not sure. I think the court was saying, weren't they, that the scheme of the legislation is, instead of having an adversarial process, is to install the special commissioner, as it was then, as the monitor instead. That's the scheme of the legislation. That there may be consequences, as you've suggested, about compromising the investigation, but that wasn't the basis of the reasoning. The basis of the reasoning was that the scheme was that to have the monitor instead of the adversarial process.
My lady, I appreciate that's part of the theme of this reasoning, and that comes more strongly through in Darren. But at the end of paragraph 49, it says his argument is that both on the principle and authority, the self-evident risk of compromising the investigation shuts out any possibility of an oral procedure. So that's the argument the court was dealing with. I hesitate because I know my lady was in this case, but in my submission, the argument being dealt with is the argument about compromising the investigation, which I believe, well, I submit, is picked up in Darren.
Well, that's a policy point behind it, but the argument was about the scheme of the legislation, and that Parliament had chosen, instead of, as it might have done, an adversarial approach in which both parties see each other's cases and have the opportunity to respond to each other's cases, to install a judicial body as monitor of what the revenue is doing, and to introduce specific safeguards.
But as we saw in Wiseman, that decision by Parliament does not necessarily mean that all other options are off the table.
Well, I'm just putting to you that that's the underlying basis of the conclusion in Morgan Grenfell, rather than simply policy. But I may be wrong about that.
Well, my lady, my submission is that if Parliament has decided that a judicial monitoring approach is correct, and then the taxpayer comes along and asks for a right to be heard, it is relevant and even necessary, I say, to consider the purpose for which Parliament has chosen that judicial monitoring system in considering whether a right to be heard should or should not be allowed on a full or a more limited basis. So I'm not sure that they're alternatives. They're sort of together in the sense that there is a judicial monitoring system. The reason for that is, let's say, concerns about compromising the investigation. Interpreting that scheme consistently with its purpose, should a right to be heard be granted? And the Court of Appeal here says no, and its reasoning is by reference to the only two logical outcomes, one of which is you learn nothing about the HMRC position, and the other is that you learn things you're not supposed to know. And my submission is that the premise of that is that you're not supposed to know anything about why HMRC want the information. And that's important because that's not the case anymore. In Schedule 36, paragraph 3, subparagraph 2, indent E, HMRC have to tell you why they think this information is required. So the law has moved on in that way. And there's another problem, if I may submit, with both Morgan Grenfell and Darren, which is I think it's more Darren, the reliance on the presumption of regularity, which in my submission has been overruled by the Supreme Court in Appellants. And so the presumption of regularity derives from a case called Rossminster, and it's applied in the Coombs case, which my learned friend makes extensive reference to in a skeleton argument. And essentially, the logic of it is once you've had a hearing before a magistrate or a tribunal, the burden is on the taxpayer if they want to judicially review that decision to show that it's erroneous in law. And they will not be able to do that in those cases because of a strong presumption of regularity and the absence of any access to any information if the basis on which the decision was taken. So if I could take you please to Herlambus, it's behind tab 20, I think that's probably your second authority button. And this case concerned the procedure for magistrates to issue warrants to enter and search premises and seize property under PACE Section 8. It also concerned a subsequent application under the Criminal Justice Act to hold on to material even though the warrant was accepted to have been void in the first place, or should have been quashed, was quashed. You can see at paragraph 3 sets out section 15. And the relevant provision for comparison is subsection 3. An application for such a warrant shall be made ex parte for the information in writing. And that goes back to my earlier point about the difference between may and shall. I won't tread over all ground. The procedural history was that the appellant sought disclosure of what had happened at the hearing, but got a redacted copy. Applied for an unredacted copy and was refused. The warrant was then challenged by judicial review, and the police agreed that the warrant should be quashed. But they applied to hold on to the seized material. And in order to support their case for holding on to the material, they sought to rely on withheld material. And the second judicial review challenged that reliance on the withheld material. Paragraph 11, you can see the issues. And ultimately, there are two questions. One, can the magistrate rely on material that cannot be disclosed to the subject, or the person to whom the warrant relates afterwards? If the magistrate can rely on such withheld material, what happens on a judicial review to challenge the warrant? Does the court reviewing it proceed without seeing the material in which the warrant was based? Does the court say it must be disclosed if it's going to be relied upon to support the decision in its judicial review? Or can the court in a judicial review hold a closed procedure to deal with that particular part of the evidence? It's notable at 25 that the criminal procedure rules have specific provision dealing with that type of application, which did require, which expressly allowed withheld information to be relied upon, and said it must be dealt with in private unless otherwise directed.
Yeah.
The court concluded, you can see at 27, that the scheme of the legislation did permit the magistrate to rely on material that cannot be disclosed. But I just want to, if I may, at this stage, show you the protections, the ancillary principles and protections that the Supreme Court relies on. And so for that, can we please go back to paragraph 60? I have to read 60, including the quote from Lord Wolf, Chief Justice.
Yep.
And then can I ask you to read the subparagraph 10 quoted at paragraph 17?
Yep.
And then the quotes at 27.2 and 30.5 at 18.
Yes.
So the point of that, showing you those passages, is that where someone challenges a warrant that's being granted on this ex parte procedure, the expectation, indeed right, is that after that hearing, they will be able to see the information and basis for granting that warrant subject to withholding material on specific grounds. There is clear read across in my submission from that situation to the present time situation, insofar as after the information notice hearing has been decided, and if it's been granted, then applying those very same principles and ancillary protections, the taxpayer or the third party is going to be entitled to see what was relied upon in the hearing, what the reasoning was, subject to making out a case for withholding information on public interest immunity grounds. We then go forward, please, to paragraph 28, where the case of Rossman is which dealt with section 20C of the Taxes Management Act, the judicial review to quash a warrant.
So sorry, where are you asking us to go to?
Paragraph 28 is the introduction.
Yeah, I've got that, yes.
You can see below the quote, a warrant was issued and executed in relation to specified premises, including those of Rossman's and Management Company. No information was given about the precise nature of the alleged fraud or when or by whom it was committed. They apply for judicial review to have the warrant quashed.
Yes.
And you can see at 29, the House recognised the invasive nature of the warrant, but as the majority pointed out, the House was not concerned with unauthorised executive action with an issue involving construction of application of a statutory scheme. There was no basis for reading into section 20C or for deriving from the general law any requirement to give particulars of the offence to the suspect. Can you read paragraph 30, please?
Yes.
At the top of 31, the reference to a general public interest immunity covering investigations into possible criminal offences may need qualification. Indeed, in the judgment of the Divisional Court in Westminster, which was approved by the House of Lords, Lord Justice Everly suggested a more focused approach depending on the particular circumstances. So that's beginning to call into question the decision in Westminster. You can see at 33, Mr. Summers submits that Westminster case is a product of an earlier era. It is true that it was decided both before the Convention rights were domesticated by the Human Rights Act and before the decision in Nairobi. But the case itself was also enacted in the same era, not long after the decision in Westminster. There may be other aspects of the decision in Westminster which require reconsideration in the light of subsequent developments. And it says it's relevant background. And then we go forward, please, to 47. In fact, if we can, 48 summarizes the approach taken in Rossman. So if I could actually read 48, please. that's the presumption of regularity. Paragraph 50, Westminster dates from a period when the principles governing judicial review were at a relatively early stage. The line of authority discussed in 47 and 49 dates from a period prior to the domestication of convention rights. It is clear from the judgment of the first of such cases, Cronin, the recently domesticated convention rights were very much in Lord Wolf's mind. Mr. Summers submits that the Supreme Court should therefore now take a very different approach. At 51, I just want to show you first the sentence, 4 lines down, sorry, third line towards the end. There are also 2 later decisions which could be said to lend support to its continuing existence, i.e. the continuing existence of the Westminster principle. And then talks about those 2 cases, but then goes on 7 or 8 lines up from the bottom. On the other hand, in the still more recent judgment in Concordia, Mr. Justice Marcus Smith considered that the exclusion from consideration by the Court of material which would be improperly considered ex parte when the warrant was granted, but which was had on public interest grounds to be withheld, an inter partes charge, could well lead to a validly issued warrant being quashed. While the CMA is recorded as having argued to the contrary by reference to the presumption of regularity, and the Supreme Court is informed that its written case referred to both Westminster and T.C. Coombs, Mr. Justice Marcus Smith's judgment does not specifically refer to Westminster line authority. And then can I ask you to read 52, please?
Yeah.
And then 59 is the conclusion of the Supreme Court, which in my submission is a rejection of the departure from Westminster and Coombs on that point.
So on what point?
On the presumption of regularity, that you will not be allowed to see, the court will not be allowed to see what was shown to the tribunal magistrate, and therefore must presume, unless the other is demonstrated by who knows what evidence, that the decision was taken in a regular and legal manner.
I have to say, I may be wrong, but I've had to look at Paralambus in other contexts, and it is generally regarded as being authority for the proposition, really summarised in paragraph 59.
Yeah.
Namely, that in judicial review proceedings, the High Court can accommodate a closed material procedure.
Yes.
Because the lower court will have made the decision under review on the basis of, for example, redacted material. And so the High Court must be able to see that material. Does it go any further than that?
It does, because if you look at the reasoning, which goes through the Westminster and the T.C. Coombs case, and the presumption of regularity, the reasoning behind that is that, no, it's not enough to simply say, well, we must assume that the tribunal magistrate has done their job properly. Rather, the logic is, no, the reviewing court needs to see everything that was before the magistrate or tribunal.
This is a point against you, isn't it? This is saying if in the FTT you're not there and you don't get the opportunity to see the documents that the revenue has relied on and put before the tribunal in their approval application, when you on judicial review challenge the revenue as having acted in excess of their lawful powers or irrationally or on whatever basis you challenge them, the High Court hearing the judicial review application may, in a closed procedure, look at what the FTT looked at without giving it to you in order to determine whether there's any force in your judicial review. It doesn't mean that you're allowed to participate first time around.
If I can, yeah. There's a number of stages to my answer to that. First is to refer back to the fact that this shall be ex parte. So the issue we're concerned with didn't arise, and in fact there's detailed procedural rules governing that. That's paragraph 25. That's the first point. The second point is to refer you back to paragraph 16, 17, 18, it was 21, where it talks about ancillary protections. The ancillary protections are, even if you weren't there at the magistrate's hearing, you get to see everything else, everything that was referred to there afterwards, except things that can be justified as being withheld on a public immunity interest basis. So the logic is, the hearing of those types of warrants is ex parte. You're not there. Afterwards, you get to see what was presented to the magistrate and the reasons of the magistrate for granting the decision, unless a case can be made out withholding some information. And if it can, the question of what happens on judicial review was then dealt with at paragraph 59, which is not that you presume that, well, there might have been other material we can't see because it's been withheld, and therefore it's a lawful decision. No, the reviewing court has to see everything, even if that means the withheld information, which is not everything. It might be a small part of it, it might be a larger part of it, it depends, is dealt with in a closed materials procedure. So the relevance of this is that that the presumption of regularity doesn't apply. The reviewing court must see everything. And also the ancillary protections, which show that you can have your, let's assume that the tax tribunal does proceed with an ex parte hearing. The ancillary protections, which must read across to our situation, will allow us to receive afterwards the submission to the tribunal by HMRC, the decision of the tribunal and the reasons why it granted it, subject to that public interest immunity point, that there's a sufficiently good reason why this information can't be provided. But there can be no presumption that simply because something has been dealt with and raised and relied on in an ex parte hearing, that is withheld information. That is not the basis of the Supreme Court's decision. It's dealing just with that small category where there is a sufficient justification to withhold it. And as we'll see in a moment, even in those cases, the Supreme Court says, well, you must give consideration to gisting. Now, we're not going to lay down specific rules for gisting, but if there's a document that you can't disclose because it would interfere with future investigations or what have you, you must consider whether you can give the gist of the document without revealing the sensitive parts. So this is a far more open approach to what happens after these ex parte hearings than is assumed to be the case, in my view, in my submission, in Morgan Grenfell.
We're in quite a long way away from the type of investigation that we're concerned with in the present case. Also, we're getting to 1:05. Now, how much longer do you expect to be? I know we've given you, we've asked you a lot, but...
if I could have, I'm in the court's hands here because I appreciate my learned friend has to have a full opportunity. If I could have 45 minutes after lunch.
No. I mean, what have you still got to do?
I've got to do...
Well, look, I think the sensible thing is, my lord and my lady and I will have a brief discussion about this, but I think 45 minutes is too long, and you should have contingency ways of dealing with if we only say you can have another 20 minutes or half an hour.
Yes, my lord.
You must decide what are the key cases to which you need to refer us. An awful lot of your submissions have come out. It's really just going through the cases.
Yes, my lord.
Very well. We'll say 2 o'clock.
Right.